Chapter 7: The Independence of the Judiciary. Every student of history knows that many of the most significant victories for freedom and justice have been won in the English law courts, and that the liberties of Englishmen are closely bound up with the complete independence of the judges. When, for any reason or combination of reasons, it has happened that there has been a lack of courage on the judicial bench, the enemies of equality before the law have succeeded, and the administration of the law has been brought into disrepute. In particular, there have been, in the long course of English history, periods and occasions when the executive has endeavoured, not entirely without success, to control and to pervert the course of judicial decision. It was not without good reason that, in 1701, those who were responsible for the Act of Settlement were careful to provide that judges could not be removed except on the address of both Houses of Parliament. For more than 2 centuries and a quarter, that secure position has remained unimpaired, with results which are well known, and upon which it is not in the smallest degree necessary to enlarge. But, vital as the independence of judges has always been, there never was a time when it was more manifestly important than in these latter days, when the effect of so much that the executive does or permits is to render it difficult for the courts to maintain the rights of the individual. The method of attack, to be sure, is subtle enough. In Tudor and in Stuart times much was attempted in defiance of Parliament. The attempts ultimately failed, and failed signally. But despotism may be no less sinister, and perhaps even more mischievous, if it acts under the cloak of parliamentary forms than when it seeks to act in direct opposition to Parliament. Let it be granted that there may be acute and well-intentioned persons who have persuaded themselves that the rights of individuals are perfectly safe in the hands of government departments, and may properly and economically be left to be determined behind the back of one of the parties, by officials of the executive, upon principles not to be explained. But that is not, or at any rate is not yet, the general view in this country, nor is it likely to become the general view if the relevant facts are sufficiently well known. Meantime, however, judicial decision may often appear to be a stumbling block in the way of the zealous official. The official course might be so much more smooth, and the official arm might be so much more powerful, if there were no troublesome law courts to stand between the executive and the individual, the Crown and the taxpayer. It is not enough, therefore, that Parliament and the public should be unceasingly vigilant to observe and to destroy clauses in bills which, if they are enacted, have the effect of placing some departmental decision or other beyond the reach of the law. It is necessary also to be astute to preserve judicial independence against any assault, however insidious. A good example of the insidious kind of assault is to be found in the scheme, which raised its head in public a little time ago and is by no means defunct today, for the destruction of the profoundly important office of Lord Chancellor. Nobody who has given any thought to the matter is likely to deny that the special and peculiar position of the Lord Chancellor is most intimately connected with the independence of the judges. One of his duties, and one of the most important of them, is to preside over the ultimate tribunal of appeal. It is obviously necessary, therefore, as indeed the statute requires, that he should be qualified by long experience in the study and the practice of the law. As a rule, of course, he has previously held the office of Attorney General, the head of the Bar of England, and it is upon this eminent lawyer, nurtured and trained in law, and in the traditions of that bar with which he has been long and honourably associated, that the critical task from time to time devolves, of selecting the member of the bar whom he is to recommend for appointment by the King to a vacant seat on the bench in the Supreme Court of Judicature. From that high duty he has every qualification, and he performs that duty not only with the most conscientious care, but also with the most intimate knowledge of those who come within the field of choice, and with the deepest respect for the spirit, the traditions, and the duties of the bar. But the scheme is to get rid of him, to parcel out his functions among various individuals, and in particular to assign the duty of making judicial appointments to a new minister, who is to be named the Minister of Justice. Now, the name Minister of Justice would be new in England, but it is well known in some countries where the position of judges is very different from the position of English judges, and where the legal system is very different from our own. It is not necessary to consider or to criticise the systems which prevail in those countries, or any of them, but it is to be observed that, under the scheme which is proposed, it is not intended that the new Minister of Justice, if and when he is appointed, should preside over the ultimate tribunal of appeal, or perform any other judicial duties. It is not intended that he should be qualified to perform any duties of the kind, or indeed that legal training of any sort should be a necessary qualification for the office. But into the hands of that minister it is proposed to gather up all the powers of making recommendations for appointment to judicial office, by whomsoever those powers may now be exercised. The post of Minister of Justice would be upon the same plane with other posts in the government, and would be open to general competition among rising or risen politicians. A man does not need to be a pessimist in order to foresee the natural and probable consequences of such a method, if it were ever established. Sooner or later, and rather sooner than later, it is to be expected that the office of Minister of Justice would be held by somebody who, without the smallest disrespect, might be described as a mere politician. His interest in law, and in the traditions of the law, would be neither more nor less than that of any other member of the Cabinet. Instead of being at one and the same time a member of the Judiciary, profoundly conscious of his duties to the Judiciary, and a member of the Executive, profoundly conscious of his duties to the Executive, he would be a member of the Executive alone. To put the matter in another way, appointments to the judicial bench would be in the hands of an ordinary political minister, a stranger to legal training, and having little knowledge of contemporary members of the bar except by accident or hearsay. Does anybody fail to perceive what, in the long run, would be likely to happen? From time to time, as every lawyer knows, the judicial bench, even as things stand, has suffered the disadvantage of political appointments. No doubt the pressure of whips and the claims of meritorious political lieutenants have very often been resisted, but nobody who is at all aware of the inner workings of the political machine can be ignorant that pressure of this kind is frequently and forcibly employed. It is resisted, and can with firmness be resisted, by a Lord Chancellor whose knowledge of the bar is personal and intimate, and who has every inclination and incentive to maintain the highest standard of judicial competence. It is not many years ago since a certain Lord Chancellor, when a Cabinet colleague entered his room, addressed him in some such words as these: "Now, I know exactly what you have come about. You have come to urge me to appoint one of the Government's supporters in the House of Commons to the vacant judgeship. You will not, I assure you, mention his name to me, unless you wish to prejudice his chances. I am perfectly willing to believe that every one of my colleagues in the Cabinet has in his pocket or up his sleeve the name of at least one Member of Parliament who, in his opinion, is a fit and proper person to be appointed to the bench." The rebuke, for such it was and was intended to be, had on that occasion the desired effect. But how much more difficult it would be for a purely political minister to take such a stand, and how much less likely he would be to take it. But the real danger, it may be thought, is something far more perilous and far more insidious than the danger of what are now called political appointments. The Minister of Justice, under the scheme which is suggested, might not only be a politician who had no special acquaintance with law or lawyers, he would also, of course, and of necessity, like the rest of his colleagues in the government, be a bird of passage, and when the government came to an end, his tenure of office would automatically be terminated. Under our present system, with the Lord Chancellor at its head, there is a strong guarantee not only of independent personal knowledge, but also of something like continuity. Every Lord Chancellor, by the nature of things, is well acquainted with the attainments of most, at any rate, of the leading members of the bar, to say nothing of many other channels of information, including the reports of decided cases which he knows so well. He actually hears many of the members of the bar in the conduct of cases before the House of Lords, sitting as the final court of appeal. He has lived, and to a great extent still lives, in a legal atmosphere. He is able, from actual personal knowledge and his own skill and experienced judgment, to assess the relative merits of conceivable candidates for judicial appointment. And when one Lord Chancellor goes, another Lord Chancellor, who in his turn has the advantage of personal knowledge and professional equipment, succeeds to the office. In the result, there is never a time when a judicial vacancy cannot be filled by the exercise of the direct personal choice of a highly qualified lawyer, relying absolutely upon his own independent knowledge and authority. The contrast between this state of facts and the state of facts which would assuredly be brought into existence under a Minister of Justice who was a layman is at once startling and complete. Layman would succeed layman with no more than a layman's knowledge of the bar. He would not have the opportunity, even if he had the capacity, to test the merit of members of the bar by personal observation, for the reason that he would not, as he could not, adjudicate in any court. Where, then, would the real authority come to reside? Where, if anywhere, would be the reservoir of accumulated experience, to which recourse must be had whenever the duty of making a judicial appointment had to be discharged? The answer is perfectly obvious. The experience, such as it might be, would be found, and the decisive authority would undoubtedly rest, in the permanent officials who surrounded the minister. In those days, if they should ever dawn, some permanent official in the Ministry of Justice, if he were asked by a judicial visitor from the other side of the Atlantic, "Tell me, who really selects the judges in England?" might answer in no mere mood of postprandial expansiveness, but as matter of actual and sober fact, "I am the person who really selects them. The Minister of Justice is but a transient, embarrassed phantom, here today and gone tomorrow, but I am always here. Mine is the knowledge, mine the experience, and the task of the minister is simply to ratify my decision." To say nothing of the 100 other objections to any such scheme or makeshift, it may be well to mention two. All experience shows that nothing is more dangerous in public affairs than that nominal responsibility should belong to one person, while real authority rests with another. Where that method or condition exists, the person who has the real authority is tempted from time to act in a way in which he certainly would not act if he had, and was known to have, the public responsibility. On the other hand, the person who has the public responsibility is tempted from time to time, in haste or in ignorance, or in a variety of other circumstances, to act in a way in which he would never think of acting if he had real authority, and afterwards to improvise excuses. Nothing could be more sinister, nothing could be more odious than that any such division of powers should be erected into a system in the crucially important matter of making judicial appointments. But there is another grave objection which it is not possible to pass over in silence. If this evil thing, which it is desired to make public and thereby to prevent, were indeed to be perpetrated, the appointment of the judiciary would sooner or later, and again rather sooner than later, be in the unfettered hands of the bureaucracy itself. It is not necessary to attempt to forecast and to enumerate the manifold mischiefs which would not merely in all probability but of necessity follow. It must, however, be quite obvious to anyone who takes the trouble to think the matter out, that the status and the position of the judges would certainly undergo a disastrous change, that the standing and calibre of members of the bar, who were ready and willing to accept judicial office, would gradually be transformed, and that in the great and growing contest between the rights of the citizen and the pretensions of the bureaucrat, there would come to be a complete and revolutionary change of forces. Nobody who is aware of the relevant facts could dream for a moment that the public, with its eyes open, would willingly embrace a peril so menacing. The danger is that the change may be plausibly made while the public is not yet aware, or is looking the other way. The terms employed by despotism at different times and in different circumstances may vary, but its methods, upon analysis, prove to be rather monotonously similar. Everybody remembers, for example, the earlier history of interference by the executive with the judges. In the reign of James I, one Peacham, a minister in Somersetshire, was prosecuted for high treason. A sermon, never preached, had been found in his study, which contained censures on the king and incentives against the government. He was put to the rack, but no explanation could be drawn from him as to his design in writing the sermon. The writing of the sermon was relied upon as an overt act of compassing the king's death. The king directed Bacon to confer with the judges of the king's bench one by one beforehand in order to secure their determination for the crown. Sir Edward Coke, Chief Justice of the King's Bench, objected that such particular, and as he called it, auricular taking of opinions was not, according to the custom of this realm. The other three judges, having been tampered with, agreed to answer such questions concerning the case as might be put to them. Coke continued to maintain his objection to this separate closeting of judges, but, finding himself abandoned by his colleagues, consented to give answers in writing, which seemed to have been merely evasive. Peacham was found guilty, but not executed. He died in prison a few months afterwards. A little later, the validity of a grant of benefice to a bishop to be held in commendam came into question in a cause in the King's Bench, and the King, on hearing that his prerogative of making such a grant was disputed, signified to the Chief Justice, through the Attorney General, that he would not have the court proceed to judgment till he had spoken with them. Coke requested that similar letters might be written to the judges of all the courts. This step having been taken, the judges assembled, and by a letter subscribed by all of them, certified His Majesty that they were bound by their oaths not to regard any letters that might come to them contrary to law, but to do the law notwithstanding, that they held with one consent the Attorney General's letter to be contrary to law, and such as they could not yield to, and that they had proceeded according to their oath to argue the cause. The King, then at Newmarket, replied, inter alia, that their oath not to delay justice was not meant to prejudice the King's prerogative, and commanded them to forbear meddling any further with the cause till they should hear his pleasure from his own mouth. On the King's return to London, the 12 judges were summoned to the council chamber, and harangued by the King with respect both to the substance and to the form of their letter. The judges, it was said, ought to check those advocates who presumed to argue against his prerogative, which ought not to be disputed or handled in vulgar argument. As to the form of the letter, instead of certifying him merely what they had done, they should have submitted to his princely judgment what they should do. The judges fell on their knees and acknowledged their error as to the form of the letter, but Coke entered on a defence of the substance, maintaining the delay required to be against the law and their oaths. After consultation with the Chancellor and the Attorney General, who delivered opinions opposed to those of Coke, the following question was put to the judges: whether, if at any time in a case depending before the judges, His Majesty conceived it to concern him either in power or profit, and thereupon required to consult with them, and that they should stay proceedings in the meantime, they ought not to stay accordingly? All except Coke declared that they would do so, and acknowledged it to be their duty. Coke answered only that, when the case should arise, he would do what should be fit for a judge to do. Coke was suspended from his office, and not long after was dismissed, though he was restored in about 3 years to the Privy Council.